Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, you've Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you Jireh. Lord, my provider. I call you Eunice. You are my battle.
Okay, you ready?
Hello, lovely people, and a very wonderful Saturday afternoon here in London. The sun is out. We're rocking 26, 27 degrees Celsius. It's like, well, the summer is at its peak. And we are so excited and delighted to be coming your way with another edition of the program, The Community and the Law. Now, this afternoon, we're looking at what evidence we need to use in our immigration appeal and to make it successful. My guest, once again, is Lawyer Charles Asma from BWF Solicitors. BWF Solicitors, together with you and I, it is The Community and the Law, live. It's always a pleasure to have you live with me on the program, The Community and the Law. We are live on YouTube, live on Facebook, and all the social media platforms on BWTV and BW Radio. My name is Uriku Sifrimpon, and I am your host for this afternoon. And I'm so delighted to say that we're coming your way, courtesy BWF Solicitors. BWF Solicitors are trusted partners when it comes to the law. And when it is that we are airborne, we want to say thank you to them and also invite you to visit them. They work Monday to Friday between 9:30 in the morning and 6 p.m. on the 4th floor of the Anna House, 214-2218 Tottenham High Road, Seven Sisters, London, N15 4NP. You can call them on 0208 493 7340. 0208 493 7340 or 077 127 61884. 077 127 61884. When it comes to any matters of the law, immigration and nationality, family law, and all that, divorce and marriages, any form of appeal. If you want advice when it comes to acquiring a property in Ghana, if you want a lawyer to represent you in court and deal with your matters for you, talk to BWF Solicitors. I repeat the number, 0208 493 7340. And with that, let me welcome my guests and my resource person for today. Lawyer Charles Asma is a lawyer from BWF Solicitors. And this afternoon, he is going to help us look at the very important topic of how and what to get together to make your immigration application appeal successful. Lawyer, good afternoon.
Good afternoon,
How are you doing, boss?
Very well, thank you. Very well.
Good. The summer is here, so we're so excited, and I know that definitely people have gotten their bottles of water with them, and we're going to go on a journey of a lesson. And this afternoon, as I mentioned, we're looking at what to put together to make our appeals successful. Are we going to be successful this afternoon, if I may ask?
We should be, if we follow and take note and get the right lawyer to help us when we get to that point.
Well, and then I dare say that the right set of lawyers are from BWF Solicitors. So when we get to the point, ladies and gentlemen, it's time for us to say thank you to our wonderful and benevolent sponsors, BWF Solicitors. And then we get into our nugget, we get into understanding what the nugget says and learn from that. Then again, we will delve into our topic and definitely be successful when we get the right lawyers, take the notes and do the right things. Then finally, I'll go to my quiz segment where we will ask you to test your knowledge on the information we have put out. It's all live on the Community and the Law, brought to you by BWF Solicitors on BWTV. We'll be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
BWF Solicitors are trusted legal partners when it comes to the law. Thank you very much. Chiwo is here. I've seen that. Chiwo, you sent in your comment to the page. Thank you. And also, if you are here, let me see you pick up the link, share, and of course, I invite others to share as well. If you're new to the channel, subscribe to the channel, click on the notification button, and that anytime when we put any content on, you will be notified. Najim, I thank you very much. You're asking people to share. It's a very important topic we're going to look at today. What evidence do I need to make my immigration appeal successful? And Lawyer Charles Asma, as I've already introduced, our resource person, and our guest from BWF Solicitors will be doing justice to that. But in the meantime, let me also remind you that if you are writing your English language test, the IELTS, I would invite you to consult and contact the experts to help you prepare for that. It's not just about writing English, speaking English, or having both. It's about knowing the right strategies to pass the exam so very well. Get your right bands and use that for any of your applications, whether it's the IELTS, whether it's the SCLT or the CELT, or for any immigration purposes. Consult KT Educational Consult for the best training and preparation for your English language test. Call them on 07596 620154, 07596 620154, or 07512 644 041. And if you need any advice and guidance on some of these schemes that the government of the United Kingdom has introduced for nurses, skilled and workers on that route, some of the things on the shortage of vacation list, you can consult them. They will direct you to the right places. And of course, when it comes to lawyers, you know we're dealing with BWF Solicitors. And one thing really that excited us during the week is the birthday of our very own Chelsea Asabiri. Chelsea celebrated your birthday earlier in the week. We on BWTV, and of course everybody in the BWF Solicitors family, saying I call many blessings. May God bless you richly, and may you live to be, well, how many years? Whatever you wish for yourself. Chelsea, happy birthday to you. We salute you, we adore you. Keep the smile, keep the hard work going, and the Lord will continue to bless you. Happy birthday to you, Chelsea Asabri, legal administrator for BWF Solicitors. Now let's get into some knowledge building. When it comes to the deportation of migrants, there are exceptions to deportation contained within the UK's immigration laws for people facing deportation. Now listen, if you can satisfy the court that the exception outweighs the public interest in your deportation, then you can remain in the UK. I know lawyer will unpick some of these things and explain that to us. Now, the provision says that unduly harsh questions in deportation cases mean that one is looking for a degree of harshness going beyond what would necessarily be involved for any child faced with a deportation of a parent. Each case will be fact specific, and it will be important to submit as much evidence as possible to support your case. Previous editions, and especially last week, we were looking at when the Home Secretary can take your nationality away from you without the consultation or without you having to put in whatever. Now, there's another bit beyond what we learned the previous time. Now, it says that when it comes to the deportation of migrants, there are exceptions to that contained in the UK's immigration laws for people facing that situation. If you can satisfy the court that the exception outweighs the public interest in your deportation, then you can remain in the UK. What are the exceptions? I know Lawyer Charles Asma will be handling that so very well. So let's really, at this point, bring lawyer in and get some explanations. Lawyer, good afternoon once again. Deportation of migrants. What's on here?
Yeah, good afternoon. How are you?
I'm very well, thank you. Okay. I think you can hear me, can you?
Yes, I can.
Okay, now then I was going on with the nugget that you guys put out this week, earlier in the week, from Monday at least, and it's talking about when it comes to deportation, there are some exceptions. The last time I was trying to preempt that to ask that, well, can't I do anything? Can't I appeal? When they send me, can I come back and all the rest of it? Now, we are seeing that there is an exception to some extent. What is that?
Right. Thank you very much. Now, the exception that we are going to mention, um, or today's conversation of the nugget, is different from the one we had the last time. The one we had last time was about Section 40 with respect to the new amendment where the Secretary of State has the power to take or to deprive people of their citizenship if their behavior is not in conformity with the national interest. Now, um, so somebody may say, well, this is quite similar. But here, so first off, last week we were looking at individuals who are British citizens. This time we are looking at people who may not necessarily be British citizens, but they
Okay.
have right to live in the UK. So that's the uh, difference I
The
want
basic
to
difference.
point out.
Okay. All right.
Right. Now, for today's conversation, we are looking at deportation of foreign criminals. That's how the provisions put it. But we are looking at foreigners who have committed offense in the UK, even though they have the right to remain or live in the UK, they have committed offense. And for that matter, the question is, should they be allowed to stay in the UK or they should be deported to their home country? Now, under Section 32 of the UK Borders Act 2007, the powers reside for that person to be deported if the offense committed is a criminal offense of any nature, criminal offense. So
Mhm.
any criminal offense, and the person has gone through the proceedings and has been convicted of the offense and has been sentenced to imprisonment of 12 months or more, 12 months or more, then Section 32 gives automatic power for the person to be deported from the UK. So
All
that's
right.
the starting point. So
Okay.
the person is a foreigner, has right to live in the UK, has committed an offense, and the offense has led to conviction, and the conviction has led to sentencing of, and the person is going to be imprisoned for 12 months or more. After you've served your term, you are the law permits that you are deported from the UK. So the question is, how do I get around this situation? So first off, I can be
Okay.
deported. I've committed offense and I've gone in for 12 months or more, at least 1 year, and I'm out. Will I stay or I'll be pushed out? The law says you'll be pushed out. But what can I do to stay? Can I challenge or can I put in some defense? So what the law is saying is that if there are exceptions that outweigh the public interest in your deportation
Mhm.
case, then you can, the word is can, you can remain in the UK if the court is satisfied that the exceptions we are looking at outweighs the public interest. So the question is, what is this exception? So the exception is where the person's circumstance is such that it will be unduly harsh for family members, especially children who depend on this person, to be left alone whilst the person who is be it the father or the mother, is removed from the UK. So if the person is removed from the UK, and the consequence on the children left behind will be unduly harsh, then the law is that, or the position is that the court may say that there is an exception that outweighs the public interest. But this becomes a matter of assessment, and therefore what is unduly harsh for one person may not necessarily be unduly harsh for another person. So it's a case by case analysis. Now, again, if the parent in the question is able to prove, then we can consider, or the law can consider that. So what are the things that can trigger exceptions? So we're looking at, let's say, a child who depends on the mother or the father, and the mother or the father is to be ported. And here we are looking at instances where there is some level of illness or some level of their family issues that will trigger severe consequence for that child left behind. And the child to be left behind will usually be a British child. So the child is a British child. The child lives with parents. Let's say one parent is experiencing or is facing deportation. The other parent, for example, is going through serious illness or medical conditions such that it will not be possible for that child to depend on the one who is experiencing this serious medical condition. Then common sense will suggest that the one who is facing deportation has to be there for this child. So can this person then rely on this situation to say that if I'm removed from the UK or deported from the UK, the consequence for or on my child will be so serious? And the word is unduly harsh. So we're looking at illness. It could be mental health, it could be any form of illness that are such that it will be very, very difficult for the that person or the parent who is going through that illness to provide support or care for the child. So the question here is this applicable to everybody? We say no. It's a case by case analysis, and the case law is clear.
Right. So the question obviously here is, if, for instance, there's a British child involved, does it have to be, if it has to be considered, does it have to be a child of any age, or once a child is a child? I'm asking this because a child who is British and lived here for at least 7 years of their life has formed some relationships and friendships and all the other bits. Could that be brought into consideration when such an appeal is made, and also consideration for the deportation?
Yes, so the point, first off, is for the British child. But we also looking at if the child is not a British child, but we have mentioned qualifying children. So if the child is a qualifying child, including a British child, and is going through this or facing a situation where the parent is to be deported, what will be consequence on this child? So the law says has to be a child. That means the child should not be 18 years and above. And again, in terms of their status, immigration status, British citizenship for the child. But of course, a child who has lived in the UK for 7 years, by presumption, has qualified to be given, for example, settled indefinite leave to remain if the child were to apply. If the child is 10 years plus, they have qualified for registration if they were to rely on their private life to seek application consideration for citizenship. But we are looking at British children, and by extension, we can say, well, if the child is a qualifying child, then we can stretch the conversation to cover such children.
All right. So, folks, what we're looking at, the nugget was put out. It's talking about when it comes to the deportation of migrants, there are exceptions to that, and this is contained in the UK's immigration laws for people facing that situation. Now, lawyer is saying, and BWF Solicitors has quoted from HA Iraq, RA Iraq, and AA Nigeria 2022 UK Supreme Court case that If you can satisfy the court that the exception outweighs the public interest in your deportation, then you can remain in the UK. The case also continues to state that unduly harsh questions in deportation cases mean one is looking for a degree of harshness going beyond what would necessarily be involved for any child faced with the deportation of a parent. Each case will be fact sensitive and specific, so to speak, and it will be important to submit as much evidence as possible to support your case. In all these, when you are faced with a situation like that, I would advise that you speak to lawyers who know what they are doing. And my first choice is BWF Solicitors. BWF Solicitors 214 to 218 Tottenham High Road, Seven Sisters, North London. If you're going by public transport, you jump on the Victoria line, get off at Seven Sisters Station. Exit number 2 takes you to the frontage of Anna House. Fourth floor of the Anna House is where BWF Solicitors are. They work Monday to Friday between 9:30 in the morning and 6 p.m. And for weekends, it is by appointment only. Call them now on 0208 493 7340, 0208 493 7340, or 077 127 61884, 077 127 61884. BWF Solicitors are trusted partners when it comes to legal matters. What evidence do I need to make my immigration appeal successful? How do we deal with that? We'll come back after this message from BWF Solicitors.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Your trusted legal partners, BWF Solicitors. And I want to welcome you if you just joined us. This is the Community and the Law Right on BWTV on Facebook, YouTube, and all the social media platforms. Good afternoon to you all, and keep your comments in the comment section below and get your questions ready. Lawyer Charles Asma is going to help us. And the topic this afternoon is how to make an appeal and be successful. Then the question again is, what evidence do you need to have to make your immigration appeal successful? Now, the key word here is successful. Others can direct you and you may not be successful, but BWF Solicitors is going to show us how to make that very successfully. And Lawyer Charles Asma is here to do that for us. Lawyer, now the ball is in your court. Let's see what lessons we can get. What do we need to put down? What do we need to have, and how we go about it? Once again, good afternoon and welcome. How do we go about it? What evidence do we need?
Thank you very much, Bragoku, and a very good afternoon to our viewers and listeners. today's conversation is about appeals of immigration application refusals. First off, appeal is a request made to a court of competent jurisdiction to challenge a decision to refuse a visa application, be it entry clearance or in-country leave to remain. Now, the decision that comes from the decision maker will state the reasons for the refusal. And it is that reason given that the individual applicant seeks to challenge. And to challenge, mind you, it is your case. And what you are saying is that you disagree with what the decision maker has said. So the decision maker has to make it obvious. And once it is obvious, that is your first port of call in terms of what am I seeking to challenge. There might be other nuances or other bits where it will not be obvious on the refusal or decision letter, but you have to take into account if you are to go to court to challenge the refusal. And I will chip in this briefly. For example, you make an application using a wrong form, or you make an application and you did not meet specific criteria or requirement. And what it means is that the application shouldn't have been made in that manner in the first instance. The decision maker might not have picked that up, but once it goes to court, the court has the power to pick it up for consideration. So that is one thing I want to put across. Now, let's assume that everything is fine, that the right application was made, and the person met the requirement, or the person thought they have met the requirement, but the decision maker considered the application unfavorably against that applicant. So we are going to court. What am I taking to court? I have to know what the decision maker has said. So I have to check the refusal letter. So we check the refusal letter and they have said this is the reason why the application has been refused. What it means is that everything I'm going to say should aim at refuting or debunking what they have said to be the reason for refusal. If I disagree, then I have to say so backed by evidence. If I agree, then of course I have no reason to go to court. But because I disagree with the reasons, that is why I'm right.
Yeah,
So we continue. Yeah. So we continue. Now we have stated the first point. The second point is, what sort of evidence do I need? And we are mapping the evidence to the reasons cited or stated in the refusal decision letter. The reasons could be anything ranging from relationship to whatever. So let's assume that the person is making application to bring a child to the UK, and the Home Office thinks that the person does not have sole responsibility, or the person does not even have parental responsibility, or even not, the relationship is not obvious. Then it is the person's case to prove otherwise. So if it is relationship, and I want to make sure my case is clearly set out, then I have to make sure that whatever proves my relationship to my sponsor, I have been able to gather. So if I already used that and I even have a better one, I can add it. So let's assume that they did not agree that you are the father or the mother. In other words, you are the parent bringing the child. And you have now got DNA evidence. Then you are targeting this to the reason that the relationship was not obviously stated or obviously evidenced. So you have your birth certificate to prove. You also have DNA to back it. So that's one bit. Now, our aim is to make sure that we identify the reason and we have evidence to say that the reason was ill considered and therefore this should be the way forward. And at this stage, it is the court that is going to consider. So the judge will look at the evidence and say that the decision maker said relationship was not obvious or was not evidenced. But this person has now provided, for example, a DNA report showing that they are the parent. Then what else do you have to say? Then there's nothing else to say. And in most cases, the decision maker or the Secretary of State will withdraw the decision to say that we now know that it was ill considered, and so we are okay. Then the case ends. So that's one example. We're also looking at another example where the person is proving sole responsibility. And we know that sole responsibility is very, very, very high in terms of the threshold. It's very, very subjective. It's not a case of tick box. So how do I prove it? If you say that the other person is not alive, then you have to provide, for example, death certificate. So if you have death certificate proving that the other person is not alive, and your matter now goes under paragraph 279, subparagraph I sub D, then we say that, all right, the other person is not alive, and therefore it's obvious that the surviving parent has sole responsibility. And what else has the person got to show that having had sole responsibility because the other parent is dead, they actually showing or carrying out that responsibility? So the decisions they've been making all this while in the life of the child, where the child should go to school, relationship with the school, the teachers, how does the parent engage and get the report and pay the school fees and so on and so forth. If it's a matter of medical treatment when the child is not well, how does this parent do it? If they are doing it through a caretaker or a carer who is providing physical care on their behalf because they are living in the UK, then it has to be obvious, and they have to map whatever support they sent home to the fact that it goes to the person providing the physical care, and that support is given to the child. And therefore, if not for the child, that support would not have been given or sent, i.e., money remittances, tenancy, rent, or property rented for the accommodation of the child, bills paid for utilities, for the needs of the child, school fees paid, hospital bills paid, uniforms bought if the child is in school, if the child has completed school and they're even looking for employment, what other support has been given to help them get the employment. So all these things, you have to prove it. Again, we are looking at how often do you go back to where the child is to visit them, because you're also looking at emotional support. So you put all this together. I go to the country every year or every 6 months, and these are the pieces of evidence, i.e., visa stamps, and also the airline ticket, proving that if not for my child, I wouldn't have gone there. And therefore, I go every year or every often to meet the emotional needs. I also talk to my child via modern communication tools. WhatsApp communication is one that the court has embraced fully. And therefore, how do you communicate with the child? And how do you ensure that you know what is going on in the life of? So that is another example of mapping what they have said, that we do not believe that you have sole responsibility, to the evidence to disprove what they have said with a view to succeed in court. We're also looking at, for example, you have married your partner. So you can see that to be able to discuss this, we just have to rely on a lot of examples and how that example helps with the evidence to be able to win the case in court. Now, let's point this out to viewers and listeners that we are looking at evidence that are relevant. Relevant means that it is going to help your case. and not to
Okay.
undermine your case. If it's going to undermine your case, then you are shooting yourself in the foot. If it's going to help your case, then that is what we want, and even helping the case to succeed at appeal. So if you have a lot of evidence, how do I sift through to ensure that the ones I have are the ones that are targeted to the reasons they have espoused within the refusal letter?
Okay.
Now,
So, lawyer,
we also look at.
if you would bear with me, let me quickly come in with this question to ask that they refuse you, they give you a reason for the refusal, and they point out to certain things that may be outlined in the refusal letter. Do I just have to answer those questions or provide the evidence that they thought they didn't have? Just that, or the more the better. So I assume that I can add further evidence to the previous ones that I provided.
So the application has been refused, and since the date of application refusal up to the date we go to court, there may be some evidence. They are not new, but continuing evidence to prove the existing case. If, for
Okay.
example, we are looking at a child who depends on the mother or father living in the UK, and the father is saying that my child depends on me. Up to the point of application, they provided evidence of dependency, for example. Up to the point of going to court, the dependency continues. So you don't say that I have done the application and I have submitted evidence to prove the dependency and I stop. You have to continue because naturally you are taking care of your child. So you are not taking care of your child because you intend immigration application for the child. You are taking care of your child because it is your duty to do so as a parent who has responsibility for the care of the child. So the immigration application is secondary. So it's a byproduct. And therefore, if you're actually taking care of your child, then it's obvious that you have enough evidence that are continuing even up to the point of the appeal. So at the point where we have to file the papers, from the time the refusal decision came up to the point where we are filing papers or your evidence to go to court, you still
Yeah.
have things to show that you are taking care of your child. So those evidence will still be relevant because the law allows for such continuing evidence um, to be provided so that you prove the case that this is the issue, and the issue was set out before, it hasn't been settled, and therefore these pieces of evidence are still relevant to settling the issue. So
So
the
in
person,
effect,
for example,
in effect, it has to be relevant. Not necessarily going to worsen your cases, as you put it, to shoot yourself in the foot, but it has to be relevant to the case to further convince the judge to rule in your favor.
yes.
Okay, all right. Yeah. Let's continue and look at. Well, you've talked about two of those situations, proving parental responsibility, the sole responsibility bit, and the rest of it. What else would we need to add as evidence?
So we also, for example, looking at claiming that you take care of your child and you provide for the financial needs of the child or the family member or whoever is involved. How do you prove
Okay.
it? So you can prove,
Right.
as we know, with whatever means you provide. If you do by money transfer, you have to use the evidence of money transfer. If you do it through people who are traveling to the country where the family member resides to give the money to them, then such people must provide some sort of testimonial or statement to support that, yes, they are the people, they know this person, and whenever they are going or traveling to the country, they receive X amount and they go and give to the person taking care of the child for the needs of the child, because that is the instruction we receive. And to the point where possible, the person can even come to court to testify that, yes, what the person is claiming is actually true because they send me to do that. If you say that you
Okay.
send provision, you send provisions to them every quarter or every month or what have you, then you have to provide evidence of such provisions that you send through the shipping companies or the cargo services. So it's not a case of what you are saying, but a case of evidence to support what you are saying. So everything you are saying, first off, you have to state it in your statement to debunk or to refute the reasons or why the application was refused and why you disagree. So you have set the background, you have said why you disagree, and you have said to court why they should dismiss the view of, or why they should throw out the case of the decision maker and rule in your favor. This is your witness statement. The witness statement will be your oral evidence. So you go to court with your oral evidence and also go to court with your documentary evidence. There are instances where you can even go to court with photographic evidence or video evidence. But when it comes to immigration appeals, video evidence is not common. Photographic evidence, we are looking, for example, at photos, family photos that suggest the bond and relationship and also whatever activities that have been going on between the families. So photographic evidence can be relied upon as well. For example, they are telling you that they don't believe that you married your sponsor and you are going to court. And actually you went to your country, you went to marry your wife or your husband, and you have evidence. So in addition to the marriage certificate, for example, you have photos to show when you married, and photos showing you and your partner signing the marriage certificate. That is obvious evidence to suggest that, yes, we were both there, look at us, with the families and friends around, and also the officiating registrar or the minister of religion present. So these are all points that can be made and supported by relevant evidence.
Okay. Now, when you set out all these pieces of evidence and you put that in your witness statement, this is from the standpoint of the person who's making the appeal. It seems to me, and it's sounding to me, that you are there trying to push the Home Office to the wall so that they will change their decision. Do they oftentimes fight back?
Maybe you are asking if the court makes a decision against them.
Just based on what you have brought.
No, yes, of course. It doesn't end until the decision is made in court. So once the evidence is provided or is filed with the court, they come in, and they are coming to say that what they have said, they still stand by it. So the person will be cross-examined on their own evidence, which is the oral evidence or the witness statement. So the witness statement is their fact, and they will be asked to confirm whether that should be adopted or used as part of the evidence. So even though the person may have all the documents proving their case, they also have to be able to speak and speak well to confirm that everything they have said corroborates the documentary evidence provided. So, for example, this is your child. You have provided birth certificate. You couldn't provide DNA because your religion maybe does not permit you or allow you to undergo DNA test. So you only relying on birth certificate. And you are saying that you are a person with sole responsibility. The birth certificate, for example, was issued in, let's say, 2022, December, just last year, for example. And that's about 6 months ago. Meanwhile, this person is saying that the other parent is no longer in the life of the child and have never been in the life of the child since age, let's say, 5 or 6 or 10. But just last year, this person name appears on the birth certificate, showing that the person was the informant. There are some countries, especially Ghana, when you are going to register the birth of your child, they ask you who is informing, of course, and that applies to every country. So somebody has to inform the authority about the birth of the child, and the informant name will be on the on the certificate. So let's assume that the informant is the father or the mother that we claim is no longer in the life of the child. Then the question is, why is the person's name appearing as the informant? Because the word informant means they took the steps to register the child. So if they are not available, when did they take those steps to register the child? Then you have to make a case clear that, for example, the rules in that country requires that parent must inform the birth of their child. And let's say when they went to register, they asked who's the father of the child, or what was the name of the father of the child or the mother of the child, and that the people registering wanted that to be the informant. If it is the case, then there could be something provided, a letter of a sort, to support the fact that the informant is there but as a matter of requirement, and there's nothing anybody could do, whether the person is alive or dead. That's a matter of procedure. But if informant is a matter of practicality, and therefore only the person who comes forward to inform has the name appearing on the birth certificate, then if it is just last 6 months, and the father or mother has never been in the life of the child, then last 6 months or 6 months ago, the informant can only be somebody else.
Okay.
So these are the nuances of the case to do with registration of the child. Or you have father of the child, and the father of the child is stated as A. You claim that A died so many years ago, or when the child, or he did not even accept the pregnancy.
Mm-hmm.
So why is A's name appearing on the birth certificate as the father or mother of the child if they are never, or they have never been in the life of the child? Then it's a matter of procedure that the registration process or requirement requires that compulsorily the father of the child must have the name appearing, and not the one who has assumed the responsibility, or only the other parent. So these are some of the nuances that we can always address within the witness statement, and can be supported by corroborative or letters from the authority issuing that document. For example, you have registered your marriage,
Yeah.
and the marriage registration is, let's say today's date, 10th of June 2023. But the marriage took place long before registration, because your country, under its customary law, for example, requires that you can marry and register the marriage later. So yours was customary, but the registration was post the marriage date. So you want to see two dates: date of marriage and date of registration, and both dates must appear on the certificate. So let's assume that you have a certificate that shows that date of marriage is the same as date of registration. Then automatically we'll conclude that the marriage took place on this date, the same date that the marriage was registered. Now the person is trying to prove that they married before a particular deadline, especially with EU cases. The person is proving that they married before a particular deadline. But the evidence you are providing as your marriage certificate shows that the registration date is the same as the marriage date or date of marriage, because it says when married, and the date is there. And that date, if you think that it's a mistake, then the authority that made that mistake should provide a letter explaining how that mistake came about and what they have done to rectify their records. Even if the certificate cannot be reissued, there should be something to explain that. It is not the person will point it out in their oral evidence or witness statement that we married on this date, we registered on that date. When we were registering, for example, we decided to register under, we went to church to have it blessed by a minister of religion, and we received the marriage certificate, and the marriage certificate is in the form of the ordinance marriage. However, our marriage was under customary practice. So when the certificate was being issued, whoever the minister that issued the certificate, if it's within the church, should have indicated that date of marriage was the date the customary marriage took place at home, and not the date the marriage was blessed. So if it's a mistake, then they have to write a letter to explain that this is a mistake. Because if that is the case, then a person cannot say, for example, that they married before 31st December 2020, or they married before 1st of January 2021. So these are some of the examples that we can really drill down to point to the evidence.
Well, folks, if you just joined us, we're live on BWTV, and we're looking at what evidence you need to make your immigration appeal successful. And lawyer Charles Asma from BWF Solicitors is taking us through the evidences that you need to point out. You appeal to the court, and the judge will look at your evidence. And law is telling us that you need to put your witness statement together, get evidences that need to go corroborate your case and prove to the Home Office that the decision they made was wrong. How do you go about that? Who helps you to do that? He's giving us all those details, but we'll be taking a quick break. When we come back, we're going to look at a situation where you do your presentation in court. What support do you need? Do you have to go to court with a lawyer, a solicitor, as a barrister? I think the difference will come in. Then again, in court, do you have to be there in person or not? All these will be unraveled when we come back. Then we go on to pick up your questions and your concerns as well. So put them in the comment section below, either on Facebook or YouTube. And also make sure you share the link, and others will have the benefit of enjoying that. If you missed any part of the program, it will be live and, of course, kept on our Facebook page and YouTube page for as long as it will be there. The internet, don't forget. That's it. Rebecca Mwako, thank you for coming. Wumpini Adam, you are welcome on board. Najima, Tilly Duma, and all the wonderful people. Thank you for coming. This firm is amazing. They know the law, and this application one from Wumpini Adam. Nanajima, kindly share the video into your various platforms or groups, because everybody needs to have this wealth of knowledge. We're moving and soldiering on, and this one, Harriet Maunyo Ejame. Harriet Maunyo Ejame. Happy birthday to you. Madam, God bless your new age. Yes, I think you were referring to our dear sister who celebrated her birthday earlier in the week. Keep your comments coming. If you have a question, you can put that in the segment and the comment section. And when we come to the segment, we'll pick that one up, and lawyer will address that. It doesn't necessarily have to be about the topic that we are treating this afternoon, but you can bring in any legal question, and the lawyer will be gracious enough to really address that. What evidence do I need to make my immigration appeal successful? We'll be right back. BWF Solicitors, thank you.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. he is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
We're live on BWTV. Welcome back. BWF Solicitors, thank you very much for your kind sponsorship and support. And to all our viewers out there, so many of you, thank you. Let me know where you are and just nudge me with your comment and your statements, and I'll pick them up and put them on for lawyer to look at. If you have a question, don't hesitate to ask. The text number, as we normally do, is 079, that's for WhatsApp, 07950422780, and for text 07399 208468, 07399 208468, and we'll push that to lawyer for him to address for us. And remember, BWF Solicitors, you call them on 0208 493 7340, 0208 493 7340, and the emergency number 077 127 61884, 077 127 61884. We have with us from BWF Solicitors our dear friend and a trusted guide, a trusted guide, so to speak, when we are navigating through the land of law. We're talking about Lawyer Charles Asma. Lawyer Charles Asma is helping us to answer the question what evidence we need to really submit to make our appeals successful in court. He's talked about the conditions and the situations, the categories of whatever you have to find yourself in, and also has explained how you can put your evidence together. Now, having done all those, and in court, what happens? Can I not attend court? Can I just leave it in the hands of a solicitor, barrister to do for me? Or what happens? Lawyer, when we have gathered the evidence, we've put our statement together, witness statement together so very well, possibly with the help of your expertise, so to speak. And then we have a beautiful bundle. We send to court. What happens in there?
Right. So you're asking whether you can opt to attend court or not. It is your case, and you are the principal witness. So you have to attend court to provide oral evidence to support your case. But at the time of making the appeal application, you will be asked whether you want your appeal to be decided on papers only or oral hearing. So if you choose oral hearing, then you have to attend court to speak together with other people that you have identified as witnesses. They have to appear in court. And star witness is always the sponsor. If now the appellant or the person whose case we are talking about, if the person is in the UK, they have to attend court with their sponsor. If the person is not in the UK, then they do not have to attend court. Only their sponsor will attend court. Of course, the person can request the court to be given opportunity to participate in their own hearing. That is also allowed. In this case, you make application to the court so that the matter for jurisdiction is settled. If it's a matter for jurisdiction, for example, if you are going to join the conversation from abroad and it is online, if it is face-to-face, you cannot travel to the UK, so obviously you are exempted. But if it is online and you can join from abroad, you can seek permission for the court to give you that opportunity to be part of that hearing. So that is the bit where you can opt out or opt in if you are an applicant or the main applicant whose case we are talking about. So the witness is always the sponsor plus any other witness, i.e. friends and families who are aware of the circumstance, especially if it's a matter of relationship or matter of marriage or matter of family life, that you might have friends and family to who are aware of the familiar life of those couples. So they can step in to give witness to that case. But in that case, they have to provide their witness statement and appear in court to be examined on their own oral evidence. So that is whether you can come or not come. If you opt for papers, you don't have to appear. Everything is sent to the judge. That's the bundle of evidence. And the judge, when ready, the matter is called, will look at it at their own time and make a decision. But how do you convince the judge if you are not present?
Mhm. So then it goes to say
Therefore,
that it's better to be in court even though you would have provided a witness statement.
you provide witness statement to be part of your evidence, but when you appear, you have to confirm that you want the statement to be part of the evidence. So it's not automatic. You have to adopt it. You have to confirm that it is to be used as evidence. And because of that, it will be tested by way of examination on that. That's why we say you are going to be cross-examined on your own statement. You have said this, you have said that. We'll ask you questions, and the question will come from the opponent who thinks that they are right in refusing you. And you are saying they are wrong in refusing you. And this is why you think so. So they are going to question you based on what you've said to be your basis of rebuttal. Then, of course, you have that. But what we are saying is that it is always advisable to appear in court because the judge will look at your demeanor, your body language, how you speak. When we are not truthful, we tend to sometimes it can show in our expressions and body language. So the judge will look at all that. And of course, the way you speak, if you are being cross-examined, the way you speak will point to the fact that, hang on, what is the caseworker or what is the home office saying? It's obvious that the marriage is genuine. It's obvious that they've been living. It's obvious that it's somebody who cares so much about their family member. Then the judge will support you on paper, and that will confirm. So the judge will say that in the witness's own evidence or the appellant's own evidence, they asked them this question and they said this, and I believe them. Then if the judge says,
let's look at sorry to interrupt. Let's look at it this way. Yeah, there is some psychology around it here. The body language. You would have put a lot of beautiful pieces of evidence on paper as your witness statement. But when you get into court, it might be quite intimidating. You look at the lawyer from the Home Office. You look at the judge who you have the perception about that he could decide your fate in there. So you're anxious. You kind of a bit apprehensive. What's going to happen and the rest of it? If that happens, might probably put you in a situation where your body language might not be too positive. Does the psychology play any part in here?
Well, if I say body language, I'm talking about body language that show. So there is a thin line between truth and confidence. Somebody may be truthful, but they're not naturally confident, and therefore you might think that they are not telling the truth. Some people are not truthful, but they are confident, gives them some point. What we are saying is, if it is your fact, you have full knowledge of the fact. So even if you are stammering or you are not forthwith in terms of your confidence is not obvious, at least what we are saying, we can say that or see that, okay, they asked them this and the explanation they gave, it's obvious that they know what they are talking about. So, I mean, how do you get around that? It's about knowing your own statement. Yes, you mentioned that the lawyer will support with the drafting of the statement, but the lawyer is drafting what they have received from the person whose case is being built. The person will tell the story. So, BWF solicitors, for example, will tell the people, what is your story? Give us your story from the beginning to the end, up to the point where the visa was refused. And even after that, what has happened in terms of your family circumstance and your relationship and everything. So they will give you a story. And you tell them that whatever story you are telling us can be tested in court, because that's what you are going to. So if you're able to tell me all this now and you ask the same thing in court, then obviously
you should be able to answer.
It's your case. You should be able to give certain answers. And here I will say to viewers and listeners that don't say that, lawyer, that is why I brought the case to you. So you say whatever you want to say. No, it is not the lawyer's case. The lawyer is supporting you. And when it comes to the fact is your fact. The lawyer will use the law to support your fact. So the fact should come from you. Why is your child's father not in the child's life, and therefore you are solely responsible? That should not come from the lawyer, because the lawyer has no knowledge of your family circumstance. It should come from you. Why have you not visited your child for the past, for example, 3 years? Meanwhile, you have leave to remain and right to go and come. Why have you not gone to visit them? You should be able to explain. You don't give it to the lawyer to assume and say it for you, because the lawyer may not say the fact as you should be. It is your fact.
Okay.
The lawyer will help you to put the fact in perspective. You may not be able to put it properly, but the lawyer then can assist. Okay, so this is what you mean. All right, then that is fine. It is properly set out in the context of what the court requires. But it is your case. So you start from when you were born, when you had your child, up to the point you traveled. When you were traveling, who did you leave the child with? And what has been the engagement? And since you came, how often do you go? If you don't go, why don't you go? All these things you say. So if you are talking to, if you are giving the instruction to the lawyer at a point where your statement is being prepared, and you go to court, and you have gone through your statement, there's something you call stress testing. You stress test your statement and you have mastered it, understood it, and you know that this is what it is. And every point, every question that may arise from that, you'll be able to explain. That's all. That's what I tell people, that look, it is your case. So whatever way they pick or which part they pick to question you, you should be able to give explanation that will be convincing. So somebody can have fantastic statement, but when it comes to the oral evidence, remember when you are giving the oral evidence, you do not read from the statement. So it's not like you are going to read to court. You are going to speak based on the questions you are asked. And nobody knows the sort of questions that will be asked, but we know that the questions will cover the things that the case worker said as reason for refusal and even more. So you should be able to have full understanding of the fact and be able to explain when you are put on the spot with the fact. So yes, you need confidence, but it's also about understanding your story and be able to explain yourself when you are asked. And I tell people that if you are not asked A, don't talk about it if you are asked about C. They ask you a particular question and you deal with that. So if you are working closely with the lawyer and you are giving the lawyer full fact, the lawyer will be able to support you with the law so that you go to court ready to be able to explain yourself when asked any question.
Lawyer, let me also ask, beyond the decision that the judge will make, would that end the story? For instance, I've appealed against the decision. I provided the evidence. A lawyer has supported me, taken me through, and guided me. I've provided my written statement, and orally I've answered all the questions in court. And the judge says, no, I am upholding the decision of the Home Office. Is that the end of the story?
The law requires that at that point, you you seek permission to appeal against the decision, and that should be a matter of error of law. Error of law means that the judge who decided the case did not interpret the law properly, and therefore, based on the understanding and interpretation of the law, the findings were also different, or the findings were wrong, and that affected the way the law was applied to the factual finding. And once we identify that there's error of law, then you challenge that if the judge had not made such a mistake, the outcome would have been different. And it's often the case, it's sometimes the case that the original decision will be set aside and a fresh decision will be called for hearing to take place.
From a perspective of BWF solicitors, how often do we succeed in appeals?
I would say our appeal rate is about 99.9%. And even those instances where
I rolled my eyes because then you don't fail, do you?
Yes. So, but you see, I didn't say 100%, 99.9. What it means is that minute, I wouldn't say failure, but that minute rejection in court could be as a result of so many other factors. And as I said, the fact comes from the person whose case we are championing. And we as lawyers, we use the law to support the person's case. So if that is your case and you go to court and they ask you a question and you say something else, is that the lawyer who didn't use the law, or you, the fact holder, who didn't put your fact right?
All right.
Yeah, in that case,
well,
the person, the appeal may be dismissed, but dismissing the appeal doesn't mean that the lawyer didn't do what needed to have been done, but it means the cross-examination was such that the person was not able to prove on a balance of probability that the caseworker is wrong.
Well, if you just joined us, you are still with us on the community and the law, and we're coming your way courtesy of BWF Solicitors live on BWTV. We're looking at the topic: what evidence do you need to make your immigration appeal successful? And Lawyer Charles Asma, our guest from BWF Solicitors, is taking us through the various steps, what you need to prove, what you need to look at, what kind of evidences you need to provide when it is about your sponsor and yourself, and then in court, what you need to do. The guidance that a solicitor or a lawyer would give you of all being outlined. You would want to ask your question. The text number is 07399208468. If you have WhatsApp, send it to 07950422780. 07950422780. I know that there are a series of questions that people have. There are a number of them that I have asked, but you would have another one or a different one you want to bring up. So at this point, I'm going to invite you to come in with your text, your WhatsApp messages, and your comments down below in the comment section on both Facebook and YouTube, and we get lawyer to answer that. Remember, we come in your way courtesy BWF Solicitors. BWF Solicitors 0208-493-7340 077-127-61884 077-127-61884. Now, earlier on in the week on BWTV, you would have joined us for free legal education and legal issues on Thursday and Friday. Thursday, we had Professor Sibriose hosting lawyer Eunice. On Friday, that was yesterday, Nam Manyete, my colleague and partner here on the program, also hosted Lawyer Charles Asman, and this afternoon I'm hosting Lawyer Charles Asman again. BWF Solicitors have given you their numbers. Another thing that I want to take note of is that we have collaborators in KT Educational Consult to help you write the English language and pass successfully. KT Ed Consult holds online classes and strategy sessions to help people pass the IELTS examination. And you can call them on 07596 620154, 07596 620154, or 07512 644 041. BWF Solicitors working together with KT Educational Consult live on BWTV, bringing you the community and the law. It happens every Saturday between 4 and 6 p.m. UK time. Text 0795042278 or 07 399208468. So let's see if we have any questions coming through. The very first one is here. I have a skilled worker visa and I want to work for 30 more hours with my second employer, but they say that my visa share codes still state that I can only work for 20 hours. What do I do? That's one question that's on there. Let me ask lawyer to quickly address that. And let me also reiterate that your questions and your concerns do not necessarily have to be about what we have discussed today. Yes, you may want to do that, that's fine. But if you have any other question like this person is brought in, we will put that to lawyer and he will help answer that. I have a skilled worker visa and I want to work for 30 more hours with my second employer, but they say that my visa share code still states that I can only work for 20 hours. What do I do? Lawyer.
Right. Thank you very much. So our questioner is asking about skilled worker and extra hours you can do. We have to understand that the employers are not required to give if they don't have to give. Some employers are playing it safe by saying that I can give you extra of 20 and therefore I don't want to go beyond that. If the employer is saying that they won't give you 30 and they will give you 20, go to another employer within the same industry to get 10 so that you can have your 30 extra.
Okay. The platform, yes, you can send a WhatsApp message 0795042278. Now, lawyer, what happens if I decide to represent myself in court when I am appealing against a Home Office decision? Is that allowed?
Yes, you can go to court on your own as litigant in person. You can also go with a lawyer or you can go with a friend as your litigating friend.
But lawyer, in court, it's the space for people who have legal brains and have been trained in that, lawyers, judges, and the rest of it. Is it not dangerous if there's any expression like that to go on my own?
Of course, it is. And the person must understand the risk level. Some people would choose this option purely on cost reasons. So you are trading off quality for work or success for work for cost. So what I would say is that you want to spend money to win your case. And if you have a lawyer, the lawyer will work with you and guide you. So even though you can, it's advisable to be supported by a lawyer.
Now, in the drafting of the witness statement, lawyer, I present the facts, and the lawyer uses the technical jargons and style of writing to put that together. Would I have to kind of rehearse the statement?
Now, the statement is written in plain English. It is a statement of fact. So it doesn't have technical or legal language. And as a matter of fact, you don't quote any law in witness statement because the person who is speaking cannot cite law or quote the law. That's why we have argument or the skeleton argument, which will address the legal aspect that the barrister will express in court. Yours is just pure fact. your date of birth, where you were born, when your child was born, if it's about child, marriage, when you married, when you came to the UK, what were you doing before you left? If it's a matter of your child, whom did you leave the child with? What have you been doing? How do you ensure that you still play a role in the life of your child? All that. That is fact. So it is expressed as simple and plain as such. And therefore, in terms of refreshing your memory, it's always good to refresh your memory, because it might be that after the period between when you completed your statement in writing for filing and the time the case is called for hearing, passage of time, and therefore you want to refresh your memory. It's fine. You can read over your statement to understand what you told the lawyer to put together for you. And you can even test yourself with that. If you ask me this, what will I say? Just like preparing for any exams, so to speak. If they ask me this, what will I say? If they ask me that, what can I say? What if they ask me something that is not even here, but it's about my life? So what are some of the things that they can ask? So you can preempt certain things. And these are things the lawyer will work with you on in terms of preempting potential areas of your life that can be tested or cross-examined.
Okay. Now, Isaac on the platform says that I hold a British passport and have been refused US entry clearance twice. What can I do?
Yes, you have to. Well, the person holds British passport. Well, what I understand is
Yeah.
that I don't think the person was refused. The person wasn't refused a visa. They might have been refused the entry clearance. There's I've forgotten the name.
Yeah, he's saying
Is it
that
ESTA?
he's been refused
Yes.
entry clearance twice. Yeah.
Yeah, but if the person has British passport, there is bilateral agreement between US government and British government so that British citizens can travel to the US without the need to get a visa or entry clearance. You go for ESTA. So you apply online for entry clearance, but that is electronic. It's not a visa. And that is more to do with your character, whether they should accept you or not. So the system will screen you to see whether this person should be allowed to enter the US. So if it's happened twice, it means there might be something that the system has picked up about you, and they have concluded that at that particular moment you are not the right person to enter the US. But what should you
Okay.
do? Unfortunately, it's not a visa application, so you have to keep trying for the ESTA.
Okay. This one here says that how much do I have to pay to appeal against a Home Office decision? And if the appeal goes in my favor, can I ask the Home Office to refund my money?
So normally you pay £140 for the application to court. And once the appeal is allowed, you get 140 refunded. So you still, well, the judge will award cost against the Home Office. So once the case is over, you go to the Home Office requesting for £140 back. But the judge may not always award the cost against them because you might not have maybe complied with all the processes up to the point of hearing. And what do I mean by that? The court will expect you to file your papers at a certain time, do certain things at certain times. And maybe your lawyer was chasing for those things and they were not forthcoming or they were not ready, you were not getting them, they can't find you, they were not hearing from you, but they were able to tell the court to give them extra time. And eventually, the evidence was provided. But the court will say that you provided not at the time that it was required. And therefore, you didn't do everything right. So even though you succeeded in court, we won't award you your court fee of 140.
What evidence do I need to make my immigration appeal successful? That's the topic we're handling this afternoon, and we're live on BWTV. If you have a text, you can send it to 079 0917-504-2280 or 0739920848. Hello, brother Kweku, please do I need life in the UK test before I can apply for IDL in the UK? IDL, I support, or I think you mean indefinite leave to remain. Okay, again, which forms do I need to fill? Lawyer.
Yes, so the person needs life in the UK test to apply for indefinite leave to remain. The form to complete depends on the person's circumstance. So we have set O, set M, set DV, and so on and so forth. So depend on the person's route to finishing their journey, they go for the specific settlement application or indefinite leave to remain application form. So if you are not sure, cross-check with a lawyer, and the lawyer will point you to the right form, or the lawyer can do it for you if you want that to happen.
Okay. Another one here says that I had a caution on my DBS, which means I have I've been arrested before through a family issue, but just last week I have received a new DBS which shows that the caution has been removed. What does it mean?
If the caution is removed, means it will no longer be on your DBS, the one that will be published for the employer or for whoever has requested for the DBS. That means it is clean now.
Okay. Another one, lawyer. If I provide a share code to my employer, do I necessarily have to present my passport and copy of it in person?
It depends on what the employer wants. If the employer wants your passport and document in person, they will tell you where to submit. And if they just want to verify, then they will not require you to go to them to give them anything. They will just use your share code to confirm your right to work.
Yeah, but the share code obviously would have catered for those pieces of evidence, wouldn't it?
But the employer will need those evidence on record as part of your file as an employee or potential employee.
Okay, right. If you just joined us, we now are the segment where we picking up your questions and comments and concerns for lawyer to address. Lawyer Charles Asma is our resource person from BWF Solicitors, our sponsors, and the program is the community and the law. If you have any question you want to send on WhatsApp, the number is 079-50422780 or text 0739920848. Hi, lawyer. My mother is 20 years now in the UK. I'm here to apply for her 20 years long stay. She's over 75 years now. Please, is the application a straightforward thing that I could do myself? Also, can I apply for a home office fee waiver for her since she has no money because she has no right to work here? Would she be able to have some support to earn a living here after the application is successful?
So I'll start from the last question.
Mm-hmm.
The person wants to know whether there will be recourse to public fund. Depending on the circumstance, if you state in your application that the person should be considered for recourse to public fund, it may be granted. Now I go to question number 2 from the bottom. Question number 2 says that, can there be a fee waiver? Yes, you can apply for a fee waiver, but you have to prove that you cannot afford the fee. Then the first question, can I do this application myself? Everybody can do the applications themselves, but just be careful.
Okay. Isaac has provided some further evidence that he was refused US entry clearance twice because he had been arrested twice and that appeared on his DBS, but fortunately he has it removed. Will that clear the way for him?
So that is why I said that there might be something that triggered the rejection. So now that there's such risk is removed, potentially, he can try again.
Right, keep them coming through 0739920848, or you can put them on the in the comment section down below. The WhatsApp number is 0795042278. Well, Isaac Befi, also thank you very much for keeping faith with us. Keep sharing the page. Let's keep it going. We have a few more minutes to go. I would want to remind you that we did a nugget on deportation and some of the situations and circumstances that will exempt you from being deported. Let's pick that back again because I will be asking you a question on that. When it comes to the deportation of migrants, there are exceptions to deportation contained within UK's immigration laws for people facing deportation. If you can satisfy the court that the exception outweighs the public interest in your deportation, then you can remain in the UK. Unduly harsh questions in deportation cases mean one is looking for a degree of harshness going beyond what would necessarily be involved for any child faced with a deportation of a parent. Each case will be fact specific, and it will be important to submit as much evidence as possible to support your case. So, watch this. I may be asking you a question on that. It's quoted from the case HA Iraq, HRA Iraq, and AA Nigeria 2022. There's a Supreme Court, UK Supreme Court case for 2022 and happened in 2022, I should say. So yes, keep them coming through. As I said, BWF Solicitors are sponsors. We want to say thank you to you for your kind support every time that we are live on Talk to BWF Solicitors. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Monday to Friday, as I said, 0208-493-7340, 0208-493-7340, or 077-127-61884. They support us to bring you the Community and the Law Saturday afternoon, legal education, and that happens Thursdays and Fridays between 9 in the morning and 10, and on Fridays at 11 in the morning. Prophet Osibrio say and Na Manyeti hosts these programs respectively, and yours truly is here Saturday afternoon with you. So trust BWF Solicitors to be on your side when it comes to the law. Nationality issues, that is all your immigration and all the other matters. When it comes to family law, they are experts. They help you with your marriage and divorce and all the other issues around it. If you want advice on property in Ghana, talk to BWF Solicitors. Now, when it comes to wills and probate, they are experts. Talk to BWF Solicitors. I give you the numbers again: 0208-493-7340 or 077-127-61884. Lawyer. Have I lost? Oh,
Yes.
okay, good. I thought I'd lost your link. I panicked for a moment. Now, the appeal, when it is granted you, how long can the Home Office chase you again to say that no, we are not satisfied with the appeal being granted you or allowed, and yes, refused? Do they have a time frame? Is there any time frame for them to come back at you and back to court to say that nah, we also have some new evidence to support our case, so we want to insist that we will have to refuse the application?
Right. I should say it's not new evidence per se, but the fact that they disagree with the way the judge interpreted the law and applied the law to make that, to arrive at that conclusion. So we say the error of law. If there's error of law, they will challenge. If it is out of country application, entry clearance, they have 28 days from the date of the decision. 28 days from the date of the decision. So the date the decision was received, 28 days will count. If it is in-country application, then that will be 14 days from the date that decision was served or given by the court. Now, what happens is that they have to make application for permission to appeal the decision. And that application will go to the original court that made the decision. And once the permission is given, they will apply to the upper tribunal for the matter to be heard. Either it will be relisted and sent back to the original tribunal for it to be heard fresh, or upper tribunal will make a decision and look at it from the point of view of pure law. So those are the dates, the relevant dates. If you want to provide new evidence, then you have to seek permission from the court that evidence should be admitted because it's relevant or necessary. Then you have to give your reason for that.
So when the Home Office appeal is not upheld and you are successful, the appellant is successful, how long do they have to oblige and give you your visa, maybe so to speak?
Well, the law says that as soon as decision is made by the court to allow the appeal, the Secretary of State should take steps to implement the decision, should take steps. And what we say as soon as possible. So immediately they have to do that. However, and administratively, it's become very challenging for that to happen because there is huge backlog. So we're talking about a lot of appeals that have been since 2019, 18, 17, and they are all happening. Some people go, they get it. Some still start outstanding and all that. And all these appeals that have been allowed have to go through implementation stage for them to get their visas. So what I would say is that once that happens, I usually would tell my client that we have succeeded in court now. We are waiting for the Home Office to say that they disagree with the court. If they don't do that, then we expect them to take decision to invite you to bring your passport. If that is a place you did your biometric. So wait for email. If the lawyer did the application, the email will go to the lawyer. If you did the application yourself and it was refused and you took the appeal to the lawyer, the original email will be the one they have or you have used. So it will come to you. So keep an eye. So that is what I tell my client, just to manage that expectation. So I would say that, yes, you have won an appeal. You have waited for 28 days. Home Office has not said anything. Or even if they said something, it's been rejected. So what happens? Wait. You'll be invited to get your visa. If you are in country, then the decision will be made and you'll be sent your decision letter to say that you have been granted. Then your card will come later. So I would say that let's manage the expectation because there's serious delay. Let's manage the expectation. But once we know that we've gotten to implementation stage, it will happen.
I'm laughing because when the appeal is granted, the person would want to have his quote unquote his freedom. The earlier the better, isn't it, lawyer?
Yes, the earlier the better, but does that not give assurance that at least it has happened? And if I've been able to wait up to now, then the few waiting periods will not create too much undue harshness for me.
Well, there's one very last one before we take a quick break and come back to our quiz. It appeared in my appeal that my interview has not been signed. I have a case. Do I have a case?
What interview?
But I wish the person could provide us further details, but that's all that's been brought in, and it's talking about appeal. It appeared in my appeal that my interview has not signed. My interviewer has not, I don't know. Whoever sent this, if you could send us further details or clarify your question, that would be very beneficial so we could have a clear answer to give you. And with that, we're taking another break and saying thank you to BWF Solicitors. And when we come back, it's quiz time on the community and the law. We'll be right back.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214-218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
We're live back on air, and we have said thank you to BWF Solicitors. Now, the next few minutes, we're going to test your knowledge. Konimo is a Ghanaian national living in the UK with his partner of 10 years and 2 children. They are aged 5 and 7. His partner and children are all British citizens. His partner suffers from debilitating depression and anxiety. Ko was convicted of drug trafficking and sentenced to 6 years in prison. He served 3 years and was subsequently released. The Home Office served him with the intention of deporting him to Ghana. He appealed, saying that the decision would have unduly harsh consequences for his family. Konimo, he lives in the UK with his partner of 10 years and 2 children aged 5 and 7. His partner and the children are all British citizens. His partner suffers from debilitating depression and anxiety. Konimo found himself trafficking drugs, was convicted and sentenced to 6 years in prison. He served 3 of those years and was subsequently released. The Home Office served him with the intention of deporting him to Ghana. He appeals against the decision, saying that it would have unduly harsh consequences for his family. What is the likelihood of his appeal succeeding? 3 options. Choose one. A, he is likely to succeed because of his partner's depression and his children's lives. 2, his prison sentence means his offense was serious, and therefore the public interest requires his deportation. So, 2 is saying he will not succeed in the appeal. 3, or C, his deportation will be cancelled because he has indefinite leave to remain. So what is the likelihood situation or scenario that his appeal will succeed? He is likely to succeed because the partner has depression and his children's lives will be affected. B, his prison sentence means his offense was serious and therefore the public interest requires his deportation. And C, his deportation will be cancelled because he has indefinite leave to remain. The clock starts ticking now. Tick tock, the clock ticks away. What are your answers? Edward Dongote Dongoyo says is A. That is number 1. He's likely to succeed because of his partner's depression and his children's lives. Rebecca Mwako, Becky says number one. Number one says is likely to succeed because of his partner's depression and his children's lives. What is your answer? Let's get going. Keep it coming. Let's go. The answers. A few moments. Let's go. We've got just about 10 minutes to wrap this up. We get the explanation and say our goodbyes. So don't waste no time. Let's get going. You can send it to the text number 0739920848 or WhatsApp 0795042270 or keep it in the comment section below on Facebook and YouTube. Let's get it going. Konimo, Ghanaian national, living in the UK with his partner of 10 years and 2 children, aged 5 and 7. All British citizens. The partner suffers from depression and anxiety. Konimo finds himself trafficking drugs and sentenced to 6 years in prison. He served 3 of those years. He was released. The Home Office says, okay, we've released you, but we're sending you back to your country, we're deporting you. He appeals and says the decision will have unduly harsh consequences on his family. Let's see, test ourselves. You remember the nugget that we brought to you. Now it talks about the circumstances that outweighs the national interest. It says when it comes to the deportation of migrants, there are exceptions to deportation contained in the UK's immigration laws for people facing deportation. If you can satisfy the court that the exception outweighs the public interest in your deportation, then you can remain in the UK. Undue harsh questions in deportation cases mean one is looking for a degree of harshness going beyond what would necessarily be involved for any child faced with the deportation of a parent. Each case will be fact-specific. And remember Konimo's situation, there are certain facts in there. The wife is suffering debilitating depression. The children, British citizens, lived here 5 and 7 years and all that. So let us go back to the question and see what answers there are. He's likely to succeed because his partner's depression and his children's lives. His prison sentence means his offense was serious and therefore the public interest requires his deportation, and C, his deportation will be cancelled because he has indefinite leave to remain. What are your answers? I've got 3. How many more? Let's see. Okay, Laura, time and tide to say with. Okay, Ademununkum says number 1. What does number 1 say? He's likely to succeed because of his partner's depression and his children's lives. Laura, now I come to you. Proof.
Thank you very much, and thank you to viewers for and listeners for participating in this quiz segment. So the law is clear that under Section 42 of the UK Borders Act 2007, if the person has committed a criminal offense and the person has been given custodial sentence for 12 months or more, after the sentence is served or within the period of serving the sentence, the Secretary of State can take steps to have the person deported. And here we're looking at foreign nationals. There might be instances where the person's deportation could be considered on humanitarian grounds, and that is what we call the exceptions. So the one exception, the exceptional part is that the situation that we are looking at, the consequence of the situation on the family of that person to be deported should outweigh the public interest consideration we are seeking to safeguard. The public interest consideration is that a criminal should not be part of the community, especially if the person is a foreigner. They have to be sent back to their country. Now, that is the public interest. What if doing so will cause problems for the families that the UK laws seek to also safeguard? So we are looking at our brother here. 6 years, that is more than 12 months. So yes, criminal offense, because we are told drug trafficking and other offenses, drugs, and other offenses. We are told that the person received custodial sentence or prison sentence. So all the boxes are ticked. But will the person's deportation bring unduly harsh consequences for the family? And here we are looking at the child or the children, 7 years and 5 years. and the partner is also involved in this situation. The partner, we are told, has been undergoing severe mental health condition, depression and anxiety. It means they are on serious medications, they are being monitored, and this man might be the one supporting the child and also the partner. So the question is, if we are to deport, or the state is to deport this man, what happens to the lady who is suffering serious depression? And what happens to the children? Who will be helping the children, their schooling and out and about, the general well-being? And if the man is also to be deported, what will be the trigger effect on the woman's condition? So it's going to even exacerbate the situation. So putting all this together, can we say that what is likely to happen outweighs the public interest? And that will fall within the exception. And therefore, we can conclude that looking at this, there's likely to be unduly harsh consequences for the children and the partner who is suffering from this serious medical condition. And therefore, our brother, it is likely that on appeal, he will succeed, because it is likely that the issues will not be good for the children.
So our answer is number one, he's likely to succeed because his partner's depression and his children's lives. Well, that brings us to the point where we, I think all the three people that really answered the question and I picked up were right. And it tells me that you've been following so well. Thank you very much. Congratulations to all of you. Well, summer is here, so I expect my prizes to be coming pretty soon. Anyway, let's go to say our goodbyes, and as tradition demands on this program, I'll hand the next minute or two, a minute and a half, maybe, to Lawyer to round up for us before we say bye-bye to you. Lawyer.
Thank you, viewers and listeners. So today we have looked at how to succeed at appeal. We've said that you have to put your best foot forward, your best evidence, and evidence should be relevant to the issues the caseworker has raised as reasons for refusal. So you map the refusal reasons to the evidence and to prove your case. You have to put together a statement, which will be your fact, and explaining each bit, and also go to court to be put so that your evidence can be tested or the witness statement can be tested. So with the oral evidence and the documentary evidence, you put together a bundle and you send to court. The evidence should be good ones and relevant to the fact we are trying to challenge. You have to do it in time, so the court will give you the timelines. If you're not able to meet the timeline, you seek extension of time so that you can do it. What we are saying is that the lawyer and the person work hand in hand. And so you have to make sure that you work closely with the lawyer to provide all the evidence early enough so that the lawyer can work with them. You will be able to succeed in court if you are able to tick all the boxes and make sure that you have put together a very strong evidence against the Home Office that what they are saying is really not true. And the lawyer of the court should allow your appeal. Thank you.
And with that, need I say any more? Thank you so very much for spending time with us, and also to Lawyer Charles Asma and the BWF Solicitors family for giving us the opportunity to learn on another occasion like this. And to my studio producer and director, Professor Ade, thank you for your hard work. To Sheila Ankra and Patmo Dodu for working behind the scenes and making this program a success. And to the researchers, all the lawyers at BWF Solicitors, Lawyer Eunice, Lawyer Charles, and the team of support workers, both in Ghana and here in the UK. I want to say thank you so very much. To Katie Ed Consult for supporting us as well. Thank you for your kind contribution. My name is Oreku Sifripon, and I want to wish you a very good evening and enjoy the summer as it has come. We'll meet again same time next week on the same platform. Have a good evening.
everybody say